Hey guys, welcome back to my channel where we break down complex legal concepts into simple, easy to understand information. I'm Ben, a lawyer based in Singapore. Today we are diving into the doctrine of frustration under Singapore law, and we will take a closer look at the Frustrated Contracts Act. Let's start with the basics. What is the doctrine of frustration? This legal principle comes into play when an unforeseen event occurs after a contract has been formed. This unforeseen event makes the performance of the contract impossible, illegal, or radically different from what was originally contemplated by the parties. In Singapore, in addition to common law frustration, the doctrine of frustration is codified under the Frustrated Contracts Act. This act provides the legal framework for dealing with contracts that have become impossible to perform due to events beyond the control of the parties involved. So, what is a frustrating event? Here are a few. Number one, impossibility. For example, if you made a contract to rent a venue for an event like a concert, and the venue is subsequently destroyed by fire, the contract would be considered frustrated. A second example, illegality. If a new law is passed that makes the performance of the contract illegal, the contract will be frustrated. So an example could be a contract for the sale of goods that are later banned. For example, a ban on bubble gum or a ban on e-cigarettes or vapes or whatever. And therefore, the contract for the sale of the bubble gum or the e-cigarettes would be frustrated. Third example, radical change. So if an event occurs that drastically affects or changes the nature of the contractual obligations, this can also frustrate a contract. For example, if a contract for the sale of goods or supplies is fundamentally altered due to a sudden embargo on export. When a contract is frustrated, it is automatically discharged. This means that both parties are released from their obligations under the contract. But this can lead to questions about the consequences for any money or benefits exchanged before the frustrating event. This is where the Frustrated Contracts Act comes into play. The Act outlines how losses and expenses should be handled when a contract is frustrated. Section 2(1) of the Frustrated Contracts Act provides that money paid before the frustrating event can be recovered, and money payable, that means has not been paid, ceases to be payable. For instance, if you paid a deposit for services that cannot later be performed due to frustration, you can get your deposit back. Section 2(2) of the Frustrated Contracts Act provides that if any valuable benefit has been conferred by one party before the contract was frustrated, the court may order the other party to pay a just sum for that benefit. Let's break this down with an example. Suppose you paid for a concert ticket, but the concert was subsequently cancelled due to a sudden ban on large gatherings, for example, like during a pandemic. So under the Frustrated Contracts Act, you would be entitled to a refund of your ticket price. If the concert organizer had already incurred significant expenses in preparation, the court might allow him to retain part of the payment to cover these costs. It's important to note that not all difficulties or inconveniences amount to frustration. The event must fundamentally alter the nature of the contractual obligations. Mere hardship or increased expense is typically not enough. Understanding the doctrine of frustration and the Frustrated Contracts Act is crucial for navigating the contractual relationships in unpredictable situations. If you are dealing with a potentially frustrated contract, consulting with a legal professional can provide clarity and ensure that your rights are protected. Thank you for watching. If you found this video helpful, please like, share, and subscribe to stay updated with more legal insights. Thanks for watching.